District Attorney Craig Northcott has set the standard that a public official's proper disclosure of residency is not an ethics issue. It's a criminal one. Now, let's look at an instance of a public official who undisputably failed to properly disclose their own property residency. Craig Northcott inserted himself into a zoning meeting, not as a private citizen, but as district attorney. He brought a state-paid assistant DA to fight a ministry from acquiring a facility next to his own home. He labeled the ministry a public safety risk, raised fears about sex offenders, described his own neighborhood as a target-rich environment, using its wealth to justify an elevated demand for protection. The standard bearer himself deceived the board by never disclosing his personal property interest. Instead, he used the power and influence of his office to tilt a zoning issue in favor of securing the value of his own property. This is abuse of office by an elected official. Jenna Amacher disclosed an address that a judge had ruled was her proper residency when Northcott tried to bully her out of the office the public voted her to fill. And now, adding insult to injury, Northcott is at it again, using the same residency issue that caused him to lose and proven wrong in a court of law. Let's compare. Jenna Amacher used a court-approved address. She faces 8 indictments, 4 felonies, public humiliation, condemnation, and life-altering circumstances. Craig Northcott hid his personal residency, abused his office for personal gain, used state resources, defamed a vulnerable group, and misled a governing body, all under his position as district attorney. Apply the standard he set by the prosecution of Jenna Amacher. How many indictments and felonies will Northcott's standard demand he receive?